Good morning, everyone. Rob Bonta, California Attorney General, and I want to say thank you all for joining this morning virtually as we announce a lawsuit against Chrome Holding Company, formerly known as 23andMe, for violating multiple California data privacy and consumer protection laws. In 2023, my office began an investigation into 23andMe for its failure to implement and maintain reasonable security measures, resulting in a catastrophic data breach, and for its misleading statements to the public before and after the breach. This wasn't just exposed usernames and user preferences, it was consumers' sensitive personal information and data related to consumers' health, genetic predispositions and risk factors, biological relatives, ancestry, and ethnicity. As I've said before, your data belongs to you and only you, not to a company, and certainly not to someone who illegally bought or stole it. When companies like 23andMe fail to protect your data and lie about it, especially sensitive personal data, then we are compelled to act. Before I get into the details, I'd like to thank my colleagues at the California DOJ, in particular our Consumer Protection Section and its Privacy Unit, for putting this lawsuit together and consistently working to protect consumers when companies fail to safeguard their data. Originally founded 20 years ago in San Francisco, 23andMe was the world's first and one of the largest direct-to-consumer genetic testing companies that used an at-home saliva sample to provide users with their raw, uninterpreted genetic sequence and reports on health risks, wellness, ancestry, and biological relatives. But the company's innovation quickly turned catastrophic when, in October 2023, the company announced a major data breach affecting nearly 7 million users across the country, including nearly 900,000 Californians. For 5 months, a threat actor exploited consumers' tendency to use weak or common passwords or to reuse passwords through a well-known cyber attack technique called credential stuffing that businesses holding sensitive data can and should be guarding against. Here, the threat actor used credentials exposed during other data breaches, including from a highly publicized breach of another genealogy site, MyHeritage, that had partnered with 23andMe. 23andMe knew that many users of its site also had accounts with MyHeritage and had even encouraged its customers to create accounts with both companies, but never checked for or prevented credential reuse, even after its partner was breached. After breaching these 23andMe accounts, the threat actor used 23andMe's DNA relatives, a feature that allowed DNA-related customers to share information and contact each other, to crucially exploit a coding error and steal additional information from about nearly 7 million customers nationally. On March 21st, 2025, after receiving reports of 23andMe's imminent bankruptcy filing, my office issued a consumer alert to educate customers on how to delete sensitive genetic data held by the company. Around 3 million users around the country submitted deletion requests, including me, by the way. 2 days later, 23andMe filed for Chapter 11 bankruptcy and its CEO resigned. We also took action to challenge the company's sale of Californians' genetic information in the bankruptcy. That challenge remains pending in the U.S. District Court of the Eastern District of Missouri, and it's separate from and unrelated to the action being announced today. I just want to be clear about that. That is a separate action, unrelated to the action being announced today. In today's lawsuit, which is about the deficient data security practices and breach of consumer trust that led to 23andMe's bankruptcy, we make clear that 23andMe failed to implement and maintain reasonable security procedures and practices appropriate to the nature of the personal information it maintained. It failed to protect personal information from unauthorized access, destruction, use, modification, or disclosure. It made untrue and misleading statements about its security measures with the intent to induce members of the public to use its services and products. And in doing so, it violated California's Genetic Information Privacy Act, Reasonable Data Security Law, Consumer Privacy Act, False Advertising Law, and Unfair Competition Law. California has some of the strongest privacy protections in the world, and we're here to put them to use, to make them meaningful for Californians. Let me be clear. In California, we will always protect the privacy and safety of all consumers. 23andMe is not above the law. This data breach and the company's handling of it was entirely unacceptable, and it also came at a deeply troubling time. The breach came to light after the data of 1 million consumers were offered for sale on the dark web, specifically touting that the data belonged to Asian American Pacific Islanders and Jewish users. This was during the same time as a disturbing increase in anti-AAPI and anti-Semitic hate and violence in our nation. Following the breach, 23andMe worked to hide and downplay both the breach's severity and 23andMe's responsibility for it. It simultaneously engaged in ransom negotiations with the threat actor while telling consumers that there was no data security incident within its systems. The company then catered to the threat actor's demands and paid $400,000 in cryptocurrency for the threat actor to destroy the stolen data, report the exploited security vulnerabilities, and provide a cover story that mitigated the severity of the breach. Instead of protecting their customers, 23andMe left them vulnerable to an attack and then lied to consumers about it. California stands up against corporations that play fast and loose with our data, corporations that think compliance is optional. Consumers deserve accountability. Today, we're asking the court to deliver it. Justice isn't just about feeling safe in your neighborhoods and communities. It's also about feeling safe from companies that promise and fail to protect your data. Reasonable data security is not a suggestion. 23andMe may not have put consumers first, but California does. Finally, before I open it up to questions, I'd like to take a moment to thank my team who's been leading this work and fighting the good fight. They don't do it for the recognition, but they deserve it, and I'm going to give it to them. TT Win, Daniel Nadal, Ian Hogg, Belinda Chan, Stacy Schesser, Barney Eskandari, and Nicholas Akers. Thank you to a great team doing great work every day, standing up for our consumers, our Californians, and their rights. And now I am happy to take any questions that you might have.